As Justice Oliver Wendell Holmes, Jr. stated more than a century ago, contract law doesn't seek to punish a party that breaches a contract. Rather, contract law seeks to compensate an innocent party that suffers an injury from a breach. In American Standard Incorporated versus Schectman, the Supreme Court of New York Appellate Division considered what type of compensatory damages were appropriate for a party that suffered an injury due to another party's bad faith breach of a construction contract. For a number of years, American Standard operated a pig iron manufacturing plant on a 26-acre parcel of land abutting the Niagara River in Tonawanda, New York. In 1972, however, American Standard closed its plant and hired Harold Schectman, a demolition and excavating contractor, to prepare the land so that it could eventually be sold. Pursuant to the contract, American Standard agreed to pay Schectman $275,000 to remove the equipment from the land, demolish the structures on the land, and take down certain foundation and subsurface structures on the land to 1 foot below the grade line. But Schectman failed to grade the property as specified because the cost of doing so would have cost him $90,000. American Standard then sued Schectman in the Erie Supreme Court for breach of contract. At trial, Schectman argued that American Standard didn't suffer any damages as a result of his failure to grade the property. In support of this argument, Schectman offered proof that American Standard sold the land for $180,000, which was $3,000 less than its full fair market value. The trial court rejected Schectman's argument and instructed the jury that the proper measure of damages was the cost of completion of the contract, not the diminution of value of the property. The jury returned a verdict in favor of American Standard for $90,000 in damages, and Schectman appealed to the Supreme Court of New York Appellate Division.